Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, Oregon, we're going to get to talk again. Now, we went through a gut-wrenching experience a couple years ago with your Ballot Measure 114. And at that time, I said it was absolutely one of the worst pieces of gun control legislation ever to come along in the history of the United States. Fortunately, Judge Ratio down there in Harney County believed with us in part on that and ultimately ended up enjoining a large swath of that law, primarily dealing with the permit to purchase requirement, and those have never really been enacted. So things were looking a little up. He ended up with a magazine ban, not good, but at least he did not have to deal with that permit to purchase. Well, then your state legislature decided to get involved. They have drafted a bill, and what they basically are doing, I want you to understand, is they're taking all the parts of Ballot Measure 114 that the Harney County Court found to be unconstitutional, and they're just plugging it into a House bill. That's really what's going on. So today, let's spend a few minutes and let's talk about, is America's worst gun law about to come from Oregon? Okay, Oregon, here's what we're talking about. We're talking about House Bill 3075. This is a do-over on Ballot Measure 114. They say that they are modifying Ballot Measure 114. What they're actually doing is they're repealing certain portions of the law, you know, the parts that the judge found to be unconstitutional, and they're just plugging it back in through a House bill. And for some reason, your state legislature believes that that will suddenly make something that was unconstitutional constitutional merely because how it was created. That is not how it works. But to give you an idea of where your state legislature is coming from, the legislative findings or the purpose of this bill states, the people of the state of Oregon find and declare that regulation of sale, purchase, and otherwise transferring of all firearms and restrictions of the manufacture, import, sale, purchase, transfer, use, and possession of ammunition magazines to those that hold no more than 10 rounds will promote the public health and safety of the residents of this state and shall be known as the Reduction of Gun Violence Act. And there is so much empirical data to show that all of these gun control measures will do exactly that. Okay, let's go through the bill as fast as we can so we don't have a 20-minute video here. Let's talk about the permit to purchase. Yes, this bill has all the usual suspects on the permit to purchase. There have been some additions. There is extra things that have been added via the House bill that were not in Ballot Measure 114. It does create a few more exceptions to the rules here. I don't believe it makes the bill any more constitutional than Ballot Measure 114. No, it is still horribly unconstitutional, but your state legislature thinks they're doing a good thing here. Okay, if this bill becomes law, and if you do have to get a permit to purchase, if you live inside city limits, you will go to that municipal police department to get your permit to purchase. If you live in an unincorporated part of the county, you will go to your county sheriffs. There is an additional section which will disqualify you from getting a permit to purchase. That new section reads, has not within the previous 4 years been convicted of or been found guilty except for insanity of a misdemeanor involving violence as defined in ORS 166470. Okay, we're going to go ahead and link up 166470 down there for you in the description box, but it is your usual suspects, felonies. You are on current indictment and out on release on a felony, crimes of domestic violence, involuntary commitments to mental hospitals and things like that. The usual suspects that will disqualify you from possessing a firearm. Okay, now as you know, in order to get your permit to purchase, that is the permission slip you need to exercise a right, you will have to go through mandatory education. Now, this bill adds other ways by which you can actually obtain the education necessary to get the permit to purchase. Okay, so there are some new additions in this section of the bill. And so now the education required to get a permit to purchase will also include proof of completion of a training course or class for a concealed handgun license issued under ORS 166291 and 292, provided that the course includes all of the components described in paragraph B of this section. And we'll go over those conditions in a moment, but yes, it is possible that your Oregon concealed carry class will actually suffice for this. There are other ways you can gain the educational requirements, including C, prior or current certification as a police officer, corrections officer, or armed parole and probation officer, as those terms are defined in Oregon and federal law. D, certification as an instructor approved by the National Rifle Association. All right, so I guess NRA certified instructors don't have to go and do the mandatory education. And then there is an exception for former military members, veterans, but I want you to pay careful attention to the language here. Proof of qualification with a pistol, rifle, or other small arm while serving in the armed forces of the United States, as documented on a federal DD Form 214, if the qualification occurred within 10 years prior to the date of application for issuance of the permit. And then finally, also, current certification as an armed private security professional under Oregon law. So, not every single human being in the state of Oregon would have to take the mandatory firearms safety course. No, there would be certain people who would be exempted from it because they already have that education plus considerable more. For the rest of you, though, who will have to take this class, let's remember that this class must include the following topics, which means the CPL course, in order to qualify for this, will also have to include all of these topics. A, review of federal and state laws in place at the time of the class and other safe practices related to ownership, purchase, transfer, use, and transportation of firearms. B, review of federal and state safe storage laws in place at the time of the class and other practices related to safe storage, including reporting lost and stolen guns. C, prevention of abuse or misuse of firearms, including the impact of homicide and suicide on families, communities, and the country as a whole. And this is the one that's going to get a lot of you caught up because this is the live fire portion of the training, and that would require D, in-person demonstration of the applicant's ability to lock, load, unload, fire, and store a firearm before an instructor approved by a law enforcement agency. Now, the first three I mentioned to you, the educational components, there is an addition in this bill where those can actually be done online. Of course, the live fire training will, of course, have to be conducted in person. What else is new under this bill? Yeah, if you have the correct educational requirements, congratulations, but they will only be good for 5 years, and then you'll have to retake the class. Okay, you can see another change in this bill from Ballot Measure 114 is now they say an approved instructor. What the heck is an approved instructor? That too is defined in this bill as used in this subsection. Instructor approved by a law enforcement agency means an instructor who has written certification from an Oregon law enforcement agency to provide firearms training or who is currently approved to provide the firearms training required for an Oregon concealed handgun license under Oregon law. Now remember, Oregon, this bill has an emergency enactment clause in it, which means if it's passed, it goes into effect the minute the governor signs it, which means your requirement for a permit to purchase would take effect immediately. Is it going to be able to take effect immediately? No, not at all. Does the Oregon State Legislature know that? Yeah, they actually do, because if you take a look at the bill, you will also see that the law really changes around July 1st of 2026, because prior to July 1st of 2026, you're just not supposed to transfer a firearm to somebody who doesn't have the required permit to purchase. However, after July 1st of 2026, if you transfer to a person who does not have the mandatory permitting, well, then that becomes a Class A misdemeanor. Okay, Oregon, this is not new, but this was always a massive concern of Washington gun law. We had a grandfathering provision in Washington when we passed our magazine ban by just simply not putting the word possession into the statute. So the sale, commercial sale, offer for sale, importation, and manufacturing of high-capacity magazines is clearly banned under Washington law. The possession is not. Your state decided to go about it in a much more sinister way, which is they basically said it's an affirmative defense. Well, if it's an affirmative defense, it means the law presumes that you're guilty and that the burden then shifts to the defense to establish some evidence that they actually were in compliance with the law. And this is a big deal because this is an unconstitutional burden shifting. You see, when you claim an affirmative defense, what the defense is actually saying is, yeah, we did it, but we had a legal justification. However, once you do that, the law then presumes a burden of proof will be placed upon the defendant to establish that defense by preponderance of evidence. If you are incapable of doing so, you don't even get the affirmative defense instructions. If you are capable of doing so, then the burden shifts back to the prosecution to disprove it beyond a reasonable doubt. But here's the deal. Here's how your magazines are grandfathered in, and I want you to think, how the heck could I actually prove any of this? A, the large capacity magazine was owned by the person before December 8th, 2022, and maintained in the person's control or possession. You got the receipts? I mean, I have no receipt for any magazine that I have ever purchased. And then how would you establish that it was always in your possession? B, the possession of a large capacity magazine was obtained by a person who, on or after December 8, 2022, acquired possession of the large capacity magazine by operation of law upon the death of a former owner who was in legal possession of the large capacity magazine. So you inherited a magazine. I mean, it might be presumed that you inherited a firearm and the magazine is consistent with that particular firearm, but now you're going to have to go back and pull up the will, the last will and testament, pull up the death certificate and all of those things to establish that you lawfully took possession of that upon somebody else's death? Or C, the owner has not maintained the large capacity magazine in a manner other than 1, on property owned or immediately controlled by the owner, 2, on the premises of a gun dealer or gunsmith licensed under 18 United States Code 923 for the purpose of lawful service or repair, 3, while engaging in the legal use of the large capacity magazine at a public or private shooting range or shooting gallery, or for recreational activities such as hunting to the extent permitted under state law, or 4, while participating in a firearms competition or exhibition, display, or educational project about firearms sponsored, conducted by, approved, or under the auspices of a law enforcement agency or national or state recognized entity that fosters proficiency in firearms use or promotes firearms education. Listen, I've been a trial lawyer for 27 years, so I understand what it takes to prove certain things. I'm not quite certain how a defendant would establish preponderance of evidence on any of that. So really, they have set the lawful and responsible gun owner in Oregon up for massive failure there. Now, there is one other addition that 3075 adds to the old ballot measure 114, and it is equally as offensive as anything else that Oregon has done to you, because they flat out state here that they will now create an unlawful gun registry, which of course will be in violation of federal law, specifically the Firearm Owners Protection Act of 1986. What am I talking about? I'm talking about the portion of the bill that reads, the department may retain a record of the information obtained during a request for a criminal history record check for no more than 5 years, except that information provided to the gun dealer under subsection 2D of this section sufficient to reflect each firearm purchased by a permit holder shall be retained and attached to the electronic record of the permit stored by the department. The department may develop a system for removal of information described herein. Notice how they say they may, but it's only under this circumstance. Upon proof or sale or transfer of the firearm to another permit holder, and for the recording of the information to reflect the transfer of ownership to the permit of the new owner. Okay, Oregon, listen, there is one other addition I want to remind you of, because I think this is a pretty good addition, because you do not have to have a permit to purchase if you are purchasing any one of the following platforms of firearms. A single-shot rifle, whether centerfire or rimfire. A double-barrel shotgun. A repeating rifle, whether centerfire or rimfire, that has a bolt, lever, pump, or straight pull or revolving action. A rifle with an attached tubular magazine designed to accept and capable of operating only with .22 caliber rimfire ammunition. A muzzleloader rifle or a shotgun with a pump, brake, lever, or revolving action. And then another exception, any active member of law enforcement, state or tribal, you're exempt from it. Any active member of the United States military, you too are exempt from it under House Bill 3075. So the statute has carved out a whole chunk of exemptions. The statute has carved out other ways in which you can get educational requirements necessary before you get the government's permission slip to go exercise a constitutional right. Does that make it constitutional? Well, if you just heard what I said in the last sentence, this still requires a permission slip from government before you can actually exercise a constitutional right. This bill is no more constitutional than ballot measure 114. Ballot Measure 114, at the time that it was being kicked around, we said was one of the worst gun laws to ever come along in the history of the United States, which means that House Bill 3075 is exactly the same. Oregon, we're going to go ahead and link it all up down below so that you can geek out on it for yourself. Now remember, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and tell us all about it. If you want to subscribe to our monthly newsletter, the information on how to do that is down there in the description box. And then finally, and most importantly, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.